Oh, it's dark, and that means it's Legal AF After Dark. Legal AF, the podcast. We had to look at the immunity decision by the United States Supreme Court, not just for the scar on the Constitution that it is, and on the legacy and integrity for the United States Supreme Court, but what happens next in the pending prosecutions against Donald Trump? I mean, as Judge Luttig recently told me in an interview, the entire Trump versus United States immunity decision by the Supreme Court was reverse engineered to reach the conclusion they wanted, to benefit one man named Donald J. Trump, even if it meant permanently imbalancing the delicate balance of our three co-equal branches of government. So what happens in the Mar-a-Lago case with Judge Cannon, who's already a Trump appointee and a Federalist Society member, now that there's been an immunity decision and a concurrence by Clarence Thomas suggesting that Jack Smith and the prosecution and the Special Counsel's office is illegitimate? What's going to happen next? We cover it on Legal AF, the podcast. Take a listen. Let's talk about somebody who never seems to get it right, which is a judge in the Southern District of Florida, Judge Aileen Cannon. I have a friend of mine who's hung up in getting her federal judgeship confirmed in the Southern District of Florida. Miss Deetra Wilder, who would be an amazing federal judge. She's getting hung up by the MAGA right there. And she's the kind of judges we need on the Southern District. And instead, we've got Aileen Cannon, Federalist Society Trumper, who it's a win-win for her, because if I had a guess, she'll be one of those judges that leaves the federal bench early, doesn't keep her lifetime appointment, and rotates out in a revolving door, or at least a one-way revolving door, and ends up in a lucrative, $1 million law firm partnership representing, I would almost say conservative, that's a bad word now, right-wing MAGA clients. Or she gets elevated by a President Donald Trump into a position that she's also not qualified for at the appellate level, or heaven forbids, at the United States Supreme Court, should Alito or Thomas, who are both mid-70s, decide they're going to step down to let President Trump, I just can't say those words out loud, pick one or two more people. The importance, we'll talk about in the last segment. It's relatively straightforward. If the Democrats win and the Biden administration win and Joe Biden wins in November, whatever combination that is, then it's likely, it's possible that we get a 5-4 Supreme Court led by the progressives and led by the Democrats. And if they don't, we'll have a 6-3 for the next 20 years. I don't know how much of a stark, dystopic landscape I can paint, but that is it. So, Dina, why don't you lead on what's going on in Mar-a-Lago, including some recent orders today, and then we'll have Karen comment on that before we end our time today, talking about the future of the presidency and immunity.
Yes, a flurry of activity there. And to your point about her leaving for a big firm, she started at a big firm. It was the same firm I started at. And so comments that people sometimes make that she's just not intelligent enough to do this case, is not true. She's just very partisan. To be honest, the fact that she is is overseeing a case against the person who just appointed her a few short years ago, why she didn't step aside, why she wasn't made to step aside is beyond me. But anyway, so today, basically, she issued this order staying the proceedings, essentially. We know that the Trump attorneys, after the Supreme Court ruling, has now argued that he should be immune from prosecution in this classified document case. And so she is delaying it, which she loves to delay it. She's delayed it so many different times already in different ways by holding so many kind of unnecessary hearings. But today she's kind of making it official in that she's stopping the discovery, anything relating to this expert testimony, all these motions that were kind of scheduled to occur in July. She's saying that they don't need to happen after all, because she's first going to determine whether or not he's immune from prosecution. And kind of what I said earlier about the New York case, how I think that how vague the Supreme Court decision is and how broad this Supreme Court decision is really going to give a huge amount of discretion to the trial court judge. Yes, the trial court judge can ultimately get overturned, but as we know, the appeals can take a very long time. And so it's, especially in a very partisan trial court judge like Judge Cannon, having free reign, let's say, by the Supreme Court is not going to bode well at all for Jack Smith. I think we kind of can already see the writing on the wall. She already didn't really want to try this case before the election, maybe not if all. And the Supreme Court just kind of gave her a bunch of breadcrumbs, let's say, in their opinion, to allow her to veer off track even more and delay the case even more. And specifically in the Supreme Court opinion, when they talk about the Article 2 core powers. And, Karen laid that out very well, how the Article 2 core powers is the one that has absolute immunity. And they describe those Article 2 core powers. And one of their phrases that they use to say what is an Article 2 power was intelligence gathering. They specifically use that phrase. And we know that opinions are negotiated. They are among the justices who are, sign on to that opinion. And I really do wonder if that phrase was specifically included as a breadcrumb to Judge Cannon. Was it a mistake that they used the term intelligence gathering when they know that he has a classified document case related to intelligence gathering out in Florida? Probably not. I think they are very specific about what language they use. So they use this very vague term, intelligence gathering, as part of his Article 2 core powers. And then kind of right after that in the sentence, they say that he is, it's his job to kind of make sure that the laws are faithfully executed and to kind of oversee the various departments. So you could argue, and Trump's lawyers will certainly argue this, that the various departments include the CIA and the NSA and the DOD, all of the agencies that whose classified documents are at issue in Mar-a-Lago. And they will argue that because it's an Article 2 core powers, classified intelligence gathering, which these documents were a result of intelligence gathering. And it is up to him to kind of oversee the departments who gathered this intelligence, that it will be, that it is within his Article 2 power to kind of, his handling of those documents can foreseeably be within that. And this is why this opinion is so dangerous, because the vagueness of it, the amount of conduct that's going to be caught in this is stunning. And especially in the hands of somebody like Judge Cannon. If we had somebody, like Judge Chutkan, they may not make that leap. But Judge Cannon, wants to make that leap. I think she's made that clear with her entertaining all of these kind of nonsensical arguments by the Trump court. Now they've given her a path to argue that the Supreme Court has included this as part of the Article 2 powers. And so, okay, let's break it down a little bit more. So there's a few charges, right, that he has in classified documents case. One is him having the actual classified documents, even though he wasn't supposed to have them, and then some having to do with the obstruction, him getting the subpoena and then not turning over the documents. I think it's going to be much harder for the Trump lawyers to say that he has immunity for the obstruction charges. At that point, he's no longer president. He gets a subpoena. He, instructs people to lie about the subpoena, right? He hides the documents. That seems very, even for somebody like Judge Cannon, that to be able to say that that is official conduct and not private conduct because he was always the president. But to Karen's point about perhaps one of the most dangerous parts of the opinion is the fact that you can't use evidence of official conduct to prove a private action is criminal. This is where this comes in, because you can argue that in order to prove that this was an obstruction charge, they're going to have to talk about how he got the documents to begin with. And how he got the documents to begin with was he was president and he was given the documents. So they have really hand-tied this prosecution to such an extent that I think it's going to be hard for any judge, but especially Judge Cannon, to navigate it in a way to allow the prosecution to have a case. The other thing is that, let's say they argue it's not Article 2, right? Let's say even Judge Cannon says that's a stretch too far. It's not Article 2. Then you get into the presumption of immunity, which is going to be really tricky, I think, for Jack Smith down in the classified documents case. The presumption of immunity is similar to, like, let's say, qualified immunity that you would have in a civil case. The problem is in applying qualified immunity to a criminal case is you already have a higher standard of proof in a criminal versus civil. You already have a presumption of innocence for the defendant in a criminal that you don't have a civil. And then they've added this extra third layer of a presumption of immunity. And, we know that Trump's lawyers are trying to argue that he was able to have those documents because he labeled them as kind of personal president, under his own Presidential Records Act, that they are personal documents and not classified documents. That seems to me, even if you say it's not an Article 2 power, seems to me that's going to be able to argue again, especially in front of a judge like Judge Cannon, to say he was president at the time, and that was part of his intelligence gathering, was part of his overseeing the CIA, was the ability to be able to classify a document as a Presidential Records Act instead of it being a classified document act. I think that is probably where she will end up. She might not go as far as Article 2, but who knows, maybe she will, but she'll probably end up that it at least has that presumption. And again, it's going to be hard to be able to introduce, evidence of official conduct. So I think this classified document case is in big trouble, unfortunately. And I think, to your point about the mess that we're in as a result, Popok, of this Supreme Court decision, is it really makes voting really so important, because the Supreme Court, I think, basically said, I don't agree with it, but they basically said the Constitution doesn't limit the presidential power. That's what they essentially said, that the Constitution didn't have that. And so then the argument is the only way to limit a presidential power is to vote in a president that you don't think is going to break the law. Like, that's the only thing we're left with, essentially.
Yeah. Well, I'll say one comment, the thing that they, of course, missed, and we covered it with Judge Ludick in the interview, is that when the framers of the Constitution had their quill pens out, they knew how to write an expressed immunity provision in the Constitution when they wanted to, but they didn't for the president because they just came off of fighting to leave a monarch who abused them in King George. So there was the opposite. They would never have done that if we were able to exhume the bodies of the founding fathers or bring them back in a time machine. They'd be like, and the framers would be like, what are you guys even thinking about? Let's hear from Karen on Mar-a-Lago. And if you could touch on also the
dissent, Thomas?
The illegitimacy of the special counsel.
Yeah, I was going to. Yeah.
Love note from Clarence Thomas, which has been received by a willing Aileen Cannon. Comment on that too, and then we can turn. We'll wrap up here.
Yeah, I couldn't agree with Dina more. This case is dead in the water because of who the judge is. I mean, if this was in front of any other judge, possibly not, but because of who the judge is, she's been looking for ways to toss this case. It was like the Supreme Court was talking directly to her, right? With what you were saying about, okay, yes, intelligence gathering. All she has to do is say, the obstruction, you can't use that. It's fruit of the poisonous tree. As you said, this evidence can't come in. He was allowed to possess it, and it's fruit of the poisonous tree. That's a concept in criminal law that fits squarely here. And she's going to dismiss all those charges. She's going to go even further than that because she was invited by Clarence Thomas. Okay, this is an immunity decision. This was nothing about special counsel. This was nothing about anything. This was about the powers of presidential immunity. And Clarence Thomas, on his own, nobody joined this dissent, by the way. So this was his own personal message to Judge Cannon, basically saying, by the way, not for nothing, the idea of having a special counsel appointed to investigate a president, that's not okay. That's not allowed under the law. And he spells out in detail the arguments of why. It's like he wrote her decision for her because he knows that there was hearings going on, right? Remember a couple weeks ago, she had these hearings on special counsel that she invited amicus briefs and then amici to come and argue in front of her. I've never seen that in the district court level. You know, the amicus, people who file amicus briefs are friends of the court. They're not parties. They're just people who come and say, look, I believe I have an interest, or I have an opinion, and I want you to hear it. And you ask for permission and you can file briefs. I've signed on to amicus briefs before, but it's always at the appellate level. Well, at the district court level, she invited them. She allowed them to come and she allowed them to argue. I didn't even know that was a thing. So this is going on in real time in front of her. And it's like Clarence Thomas, if there was any question that he's completely corrupt and in the bag for MAGA, this right here should have told you there was no issue before the Supreme Court on special counsel in this case, period, full stop. And he decides to write a dissent speaking directly to Eileen Cannon while she is considering the issue of special counsel, and spells out for her why it is that this is illegitimate. Jack Smith is illegitimate. So I'll bet you lunch, Popok, because I know we like to do this. I will bet you lunch that in addition to dismissing this case in the ways that Dina laid out so beautifully, she's going to go one step further, and she's going to rule that special counsel Jack Smith is illegitimately appointed, and she's going to do some sort of injunction the way Judge Kaczmarek did in Texas for mifepristone, and that applies to the whole country. She's going to try to enjoin him so that he can't prosecute Donald Trump in front of Judge Chutkan either. You watch. That's my prediction.
Yeah, I'll take that bet, even though I paid off the last one. I agree that she's going to. I agree that she's going to try to find immunity guts most of this case. Although I agree with and I've said it in a hot take, I agree with Dina that 99% of this Mar-a-Lago thing we call it Mar-a-Lago for a reason. Everything happened at Mar-a-Lago. It didn't happen in the White House. He's a former president, or as one of our founding fathers once said, the president rises from the masses and then returns and recedes back to the masses after he loses, or after his term is over, and he has no more Article 2 rights or executive powers or executive privilege than anybody else. And everything that he's alleged to have done at the heart of the Mar-a-Lago indictment has to do with things that were done at Mar-a-Lago by a former president. Sure, there's some conduct before and kind of packing the boxes up, but that's not the obstruction of justice charge. And that goes to everything that happened at Mar-a-Lago with his various henchmen and in the videos. But that's not going to stop her, agreeing with Karen, from mapping that immunity decision onto it in such a way as to gut the case, a case she's not set for trial. But once she makes that ruling, and I disagree with Karen, I don't think she's going to go farther and do a nationwide ban on all cases against Donald Trump on immunity once she says that the special counsel, and I'm not so sure she goes as far as the special counsel is illegitimate part. Let's just a brief tutorial to the audience on majority opinions, concurrences, and dissents, and their weight, because they're not all weighted the same. The majority opinion, even if it's supported by various concurrences, is the law of the land. And they had the benefit of the other dissents, Sotomayor's in particular, and Thomas's concurrence before they wrote the majority opinion. And that they don't mention everything in every other dissent or concurrence doesn't mean that they agree with it, because they don't have to agree with it. They are the law of the land, and the others are just color around certain issues. Now, with a passage of time, what was once the dissent could be seen to be the better reasoned argument, and is often and you'll say, well, the dissent had it right. And people can try to argue that, but until there's a change in the law, the dissent is what it is. A concurrence that's not adopted by the majority opinion is just a concurrence. It's just a sidecar. And it may give color around an issue, but not this one, because the majority opinion, by implication, does not have a problem with the special counsel's legitimacy. Because if they did, they would have gotten rid of that. They would have adopted Clarence Thomas's argument, and they would have made that ruling. And I don't think they needed further briefing on the particular issue or further record below if they really wanted to go that route. The fact that they're sending it back to Judge Chutkin in that particular case and asking her to go through the indictment led by a special prosecutor, special counsel. It means that they're okay with the appointment through the Department of Justice and through the Code of Federal Regulation with that particular prosecutor. That doesn't mean that Judge Ken is not going to be led astray by this. I think she doesn't take the bait on that particular thing. She's asked for a very quick briefing schedule. Donald Trump wanted to stretch this out till mid-September. She said, no, why don't we do it over the July? And by the end of July, why don't we have full briefing? She's going to have to make a ruling on this. And if she were to rule that the special prosecutor is illegitimate, we're going right to the 11th Circuit, where I think it'll be quickly reversed, maybe even on an emergency basis, and then maybe go back to the United States Supreme Court if necessary. But I do agree with Karen that this, and with Dina, that this effectively guts the case in the sense that it's never going to get tried before November. Now, whether the Department of Justice is being sincere, which I believe they are, that they don't care about the political calendar any longer. All of their guidelines, nothing was done particularly as a timing mechanism to influence the election or to benefit one person or the other. This prosecution was started 2 years ago. The reason we're even talking about being up against November is because of Aileen Cannon and all of her delays and accepting all of the delays of Donald Trump. And then they look at the time. We're almost done. Yeah, we're almost done because every other judge would have had this case up, running, tried, and we would have had a jury verdict already. So if the Department of Justice is right, they're going to straddle this November. They think they have till January 19, really, to get this case up and running before, heaven help us, a new President Trump would kill the prosecution, which he'll have immunity to do, and it won't be seen as obstruction under the new ruling. So I don't see the nationwide ban part, that part of it. And finally, we'll get an order, Lord knows when it'll be, sometime in August or September, from the judge that can go right to the 11th Circuit about these two major issues. And she's got other major issues that, Karen, you mentioned during our midweek a couple of weeks ago that they're just stacking up that go to the heart of the case. How about suppression of all of the evidence that was gathered during the search warrant process? I don't think she's going that far. Could be wrong. How about Evan Corcoran, who is one of the lead links in the chain of a criminal mens rea that the prosecutors have to prove beyond a reasonable doubt? One of their major pieces of evidence, we talked about major pieces of evidence and bombshell moments in trials with the New York trial, is Evan Corcoran, the former lawyer for Donald Trump, with incriminating, damning evidence against Donald Trump, which makes the case for criminal mind and mens rea. And if that gets thrown out because she's declared as a judge, she gets to look anew at all of the hearing and evidence that was conducted by Chief Judge Beryl Howell of the D.C. Circuit Court. A judge, frankly, Judge Cannon can't hold a candle to. But she says, I'm the trial judge. Everybody agrees. Before trial, I get to reevaluate things that happened in the grand jury process, and I may not like what happened with Evan Corcoran being stripped, along with Donald Trump, of attorney-client privilege, and that there being a finding that Donald Trump committed a crime or fraud. I'm going to do it all over again. That scares the crap out of me too. But again, no trial date on the books and none for the foreseeable future, right?
What I think she's going to do, though, Popok, yes, I agree with you 1,000%. But what I think she's going to do, she's going to look all the way back to the search warrant. And the search warrant is you had to establish that a crime was committed based on probable cause. And she's going to say there's a lot in there that was immune. And so it's fruit of the poisonous tree. It all gets dismissed. I just think the whole case gets gutted under fruit of the poisonous tree. Number one. Number two, the reason I think she's going to go with the special counsel's illegitimate is because she's going to dismiss this whole case against Donald Trump for the reasons we just said. But then number two, she's not going to want to be left with just a case against Waltine Nauta and Carlos de Oliveira. She's going to say that's not fair. And so that's why she's going to rule that the special counsel is illegitimate anyway, but she's going to rule that all of this was fruit of the poisonous tree, it taints both of them too. She's dismissing the whole case.
Is the fruit of the poisonous tree because while he was in the White House making the decisions about what to take and what not to take, that is totally immune.
Correct.
And so once it got there, the fact that he's hiding immune acts is no longer a crime.
Correct.
Exactly, because they said the official conduct can't be used as evidence. Like even beyond the fruit of the typical criminal thing, they articulated that in this opinion. And I think that is the argument. It's interesting your point about Popok. They could have mentioned this special counsel illegitimacy, but we know there's again lots of negotiations going on, and just because they didn't mention it, I kind of lost a lot of faith in this court, to be honest, from this opinion, because it's so far removed from their own precedent that I don't know if that's why they didn't mention it, because the fact is that issue was not in front of them. And so I could see Chief Justice Roberts kind of trying to craft this majority by arguing, hey, if that comes in front of us, we can address it, but it's not in front of us now. I'm not convinced that they don't have a majority that would agree with a Judge Cannon decision that the special counsel is illegitimate.
Well,
I don't know if we can read that far into it to assume that they did it for like good reasons or right reasons. It might have just been, hey, like we might get there, but it's not here yet.
It wasn't presented.
Yeah, exactly. It wasn't presented, and they are so far removed, I think, from any basis. They're willing to do whatever they want to do at this point.
Fundamental issues don't have to be. A Supreme Court or any reviewing court has the ability on their own to observe defects in a case, and including in a prosecution, including a fundamental defect in whether somebody's been properly appointed or not. And the reason I said it is back again, I agree with you. They don't, there was not a lot of precedent cited in the decision, but if you're going to cite precedent, like something like US v. Nixon, in which Leon Jaworski's power was being challenged, they enforced the subpoena for Leon Jaworski, who, by the way, was appointed with less of a procedural process, if you will, than the Department of Justice appointing the special counsel. That was just Robert Bork, acting attorney general during the Watergate hearings, telling the chairman of the committee that he would, to avoid an appearance of impropriety, he was planning to appoint a special prosecutor. They were like, okay, and that was it. And so here it went through, yes, there was an independent counsel rule that was eliminated by Congress, bipartisan way many years ago, but there's always been an implicit understanding that a appointment of a special counsel under the DOJ guidelines would be appropriate. But I agree with you. All bets are off. It's like I've said it before. Precedent doesn't matter. They have the votes. They have their Federalist MAGA checklist of things they've wanted to accomplish when they finally got the votes. Roe versus Wade, out the window. Check. Limit the administrative state through overturning the overturning the Chevron decision. Check. Create the imperial presidency. Check. Take down the wall between church and state. Check. This is the list. This is the Federalist Society list, and they were, when it was just sort of Antonin Scalia and then Alito and Thomas, in the minority, we were like, okay, thank God they're in the minority. But now with Gorsuch sliding over with Thomas and Alito, forming this MAGA right block, and the only thing that's holding this thing together is this quote unquote centrist block of Roberts, Amy Coney Barrett, which I've done a hot take on, the rise of Amy Coney Barrett. She may end up being the swing vote. Yeah, going into the future, along with Kavanaugh, which is what I had said in the past about be careful through the confirmation process. We may need Kavanaugh, because when Kavanaugh and Amy Coney Barrett sided with Sotomayor, Kagan, and Ketanji Brown Jackson, things that we and our audience got passed, got adopted. And when they didn't, and they slid the other way, all these terrible other things that we've now outlined happened. And so it's not the Roberts court for me. It's becoming the Amy Coney Barrett and Kavanaugh court. And that's who we have to shoot for. going forward if this is going to be the makeup. Welcome back. That's a little podcast we like to call Legal AF, and now you know why. We curate the top 3 or 4 stories at the intersection of law and politics, and we bring it to you on Wednesdays and Saturdays just like that. We sit at that intersection of law and politics so that you don't have to. On Wednesday, I do the show with Karen Friedman, Agnifilo, and on Saturday with my co-founder, Ben Meiselas. So I invite you to join our audience if you don't already know about us. That's an example. That's a little bite-sized version of Legal AF. And if you already know about us, I am requesting, I'm asking nicely if you can take that clip and send it off to people in your life and ask them to join our growing audience. We got to get to 3 million before the election. We're a independent network without outside investors. And so we're building this network with our bare hands, brick by brick, with your help. So until my next hot take, until my next Legal AF, this is Michael Popok reporting. Heary, heary, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know, and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.